Hello. Thank you everyone for joining us for this seminar on the intersection of cryptocurrency, white-collar crime, and investigations. We'll be discussing cryptocurrency regulation, types of cryptocurrency-related fraud, key court cases, and decisions, as well as investigative challenges, all from both a Canadian and international perspective. I'm Tudor Carsten, a litigation partner in the Toronto office of DLA Piper. I'll be moderating this event. I also realized as I logged in that I inadvertently color coordinated my outfit to the firm's background. I hope that's not too distracting. I'm joined today by three fantastic panelists. Christine Tabbert is the Deputy Director of Operations in the Enforcement Branch of the Ontario Securities Commission. In that role, she's responsible for overseeing case assessment, the Office of the Whistleblower, disruption, and data analytics, among other enforcement operations. Christine started her legal career by spending 15 years with a major Canadian law firm, after which she became in-house counsel and corporate secretary to the investment and mutual fund dealer businesses of a major Canadian financial institution. And just prior to joining the OSC, she was senior political staff in the federal government. Dan Jewell is a lawyer in DLA Piper's office in London, England. He has over 10 years experience in domestic and international litigation, arbitration, and alternative dispute resolution. His practice spans a broad range of sectors, including banking and financial services, energy and natural resources, and technology. Dan has a real interest in fintech and crypto litigation. Finally, Michael Fluhr is a lawyer in DLA Piper's San Francisco office. He counsels and defends companies in a wide variety of complex commercial disputes. Michael focuses his practice on the financial sector, including the blockchain and digital asset space, where he advises and defends exchanges, issuers, DeFi protocols, NFT platforms, and creators and related companies. He is also an author and editor of the book Cryptocurrency and Digital Asset Regulation, a practical guide for multinational counsel and transactional lawyers, published in 2022 by the American Bar Association. Thank you to Christine, Dan, and Michael for being here today. We'll start now with the seminar topics, and we'll do our best to leave some time at the end for questions. If anyone has any questions, please enter them using the Q&A button at the bottom right of your screen. If for some reason we don't get to your questions during the seminar, we will follow up to the email with which you registered. So to start things off, Christine, I'd like to ask you to briefly provide an overview of cryptocurrency regulation in Canada.
Sure. Well, thanks, Tudor, and thanks for having me. The idea of national securities regulation in Canada is only accomplished through national instruments because, of course, in Canada, securities regulation is a provincial jurisdiction. So national instruments are typically reserved for policy issues on traditional capital markets issues. And those who practice in this area are familiar, of course, with the giant blue book, the regulatory rules and the Act, which is filled with national instruments. The only way Canada operates together in the securities space is through guidance, not rules. So working with the CSA, the Canadian Securities Administrators, the Ontario Securities Commission has been continuously developing a regulatory framework for crypto assets for nearly 5 years within this framework of national instruments. And in 2017-2018, the CSA issued guidance on the application of securities laws to highly promotional coin or token offerings that are in substance securities offerings. And then in 2019, the CSA issued guidance that securities legislation applies to the trading of crypto assets that are commodities but not securities. So for example, Bitcoin, because the user's contractual right to the crypto asset, the claim against the crypto trading platform may itself constitute a security and a derivative. So basically, the CSA said provincial securities legislation applies to the trading of crypto assets and answered the question of when a crypto asset is a security, a derivative, or an investment contract. And then in 2020, and I'll talk about this more later if we have time, the OSC reviewed the collapse of Quadriga and issued an enforcement report in June of that year. And that was a big milestone. And then in March 2021, the CSA and IROC, which is now called CIRO, the new regulator, or the new SRO rather, published SN 21329, which outlines the regulatory framework for crypto trading platforms, CTPs we can call them, and a path to registration and eventual CIRO membership. So that really enabled our enforcement team to do more. It meant that each province was going to start the process of registering CTPs. Where they're a trading platform, basically anything that looks like an exchange, they go to CIRO for registration. In September 2021, the CSA then issued advertising guidance to address overly promotional CTP advertising. And in 2022, the CSA issued news releases in August and December outlining expectations that CTPs in the process of getting registered must file pre-registration undertakings, what we call PRUs, to level the playing field with registered CTPs and to support investor protection. And again, this idea of national securities regulation being accomplished through national instruments, these milestones I'm talking about are all either national instruments or press releases, news releases. So no new laws, just application of the existing provincial securities laws. So the OSC has been registering entities as restricted dealers on an interim basis with terms and conditions, while those firms seek membership as investment dealers in CIRO. So to sort of summarize, in Canada, we have a coordinated and collaborated approach on a PRU process, which was done in a traditional securities regulation way, the registration and the process associated with it. And there are several CTPs who have signed PRUs. So that basically means, in our view, that they've attorned to the jurisdiction, they're undertaking to comply with securities law. So investment dealers in this space are registered as members of CIRO. I believe there are currently 2, CoinSquare and Fidelity Clearing Canada. And then there are also restricted dealers, at least 8 of them, I think, in various stages of discussion, moving toward being registered with CIRO. And I'm talking about Ontario specifically now. Most CTPs have business models that only require registration as dealers. So that's a sort of a brief overview of the last, 5 to 7 years, and how the existing legislation in the various provinces has been interpreted, and how the CSA has promulgated these national instruments to help everybody understand exactly what our expectations are.
Thanks, Christine. Michael, can you provide an overview of U.S. cryptocurrency regulation? Oh, you're on mute, Michael.
Sorry, there we go. Yes, so there's really been no overarching federal uniform set of regulations that have applied to the cryptocurrency industry. Obviously, like any other industry, you have regulatory areas that apply to all industries, everything from tax to privacy to, intellectual property. But in terms of the specific regulatory regimes that so far have been applied to cryptocurrency, there's really 3 main ones, and then we can talk quickly about some others. First is the regime of essentially money transmitter or money service business licensing. So in the United States, and this is generally analogous across the world, if you're a business engaged in the movement of money, including cryptocurrency, from one person or place to another person or place, you're considered under various regulations to be a money services businesses, or in some cases, a money transmitter. And in the United States, each state, for the most part, in which you operate, so think something like Western Union or PayPal, each state in which you operate requires licensing in that state. A number of years ago, it became accepted that this regime was going to apply to cryptocurrency exchanges as well. So if you were to look at the big cryptocurrency exchanges in the US, you can go take a look at their licenses that they've acquired online. And pretty much all of them have acquired these state money transmitter licenses from various states in which they operate, as well as a federal money transmitter license. This scheme of regulation has generally proved workable. If not cumbersome, it is cumbersome because it requires compliance with 30, 40 different state money transmitter laws with individual audits from each, but it has been workable. The exchanges have been able to get these required registrations and operate in compliance with the rules they're under. The next set of regulations is where all of the problems in the U.S. legal industry lie, and that's the set of securities regulations. So there are these things called securities, which are a type of investment, and we'll talk a little bit more about that in a later part of the presentation, because it's a key element of some of the hottest cases in the United States. But there are some things that you invest in that are considered securities: stocks, bonds, notes. Those are quintessential examples. And in the United States, like in many other jurisdictions, the market and the industry for securities is very, very highly regulated. If you want to sell these things publicly, if you want to trade these things publicly, like on a stock exchange, if you want to run a stock exchange or provide investment advice about these things, you have to register with the U.S. securities regulator, called the SEC, comply with a whole host of regulations. Probably the biggest legal question in the industry in the United States is when and under what circumstances cryptocurrencies constitute securities, such that they are subject to this huge set of regulations and approval, essentially, of actions and sales and trading platforms by the U.S. regulator, the SEC, which so far has been completely or nearly completely unwilling to allow cryptocurrency exchanges to register as securities exchanges, to allow cryptocurrency issuers to sell cryptocurrencies as securities. That's the second big area of regulation, and we'll talk a little bit more about that in a second. The third area of regulation is in the commodities area. For the most part, cryptocurrencies, if they're not considered securities, are going to be considered commodities. There's some nuance around there. It's probably oversimplified, but at a high level, that's kind of the case. And the commodities regulator in the United States, the CFTC, doesn't comprehensively regulate the market for commodities. It comprehensively regulates the market for commodities swaps, futures, derivatives, options, and exchanges. So in the United States, if you want to operate a cryptocurrency exchange, to the extent those are considered commodities, the CFTC doesn't comprehensively regulate that. To the extent you want to operate a cryptocurrency futures exchange, like a Bitcoin futures exchange, that's comprehensively regulated by the CFTC. Fortunately, on that front, the CFTC has proven more willing to work with the industry to allow registration of things like Bitcoin futures exchanges and Bitcoin futures products. It's still a set of onerous regulation, but at least the CFTC has provided workable solutions. So those are the three big areas of regulation in the U.S.: money transmission law and money services businesses law, securities, and commodities. On top of that, you have New York in particular, and other states are kind of moving in this direction. Some states like New York are enacting specific laws that say if you want to operate a cryptocurrency specific or digital asset specific business, here are these extra sets of regulations. We need to approve it. You need to come apply and register with us. In New York, it's called the BIT license. That's sort of kind of progressing slowly, but that's where we are in the United States.
Thanks, Michael. Appreciate that. Dan, can you quickly fill us in on the applicable UK regulation?
Absolutely. Thanks, Tudor. So it will be brief as well, because I should say I'm not a reg lawyer, but the rules are quite interesting because they've just changed actually this week. So the UK's general approach is to bring them within the existing framework relating to financial services, rather than having bespoke crypto legislation. And they've got two aims, really. The aims are protect consumers, but also don't discourage innovation, because the UK is very keen on crypto taking off and being a very attractive jurisdiction for these sorts of products. So what they've done is they've brought in the Financial Services and Markets Act 2023, and that now regulates the management of arrangement of dealing in crypto, and it also deals with financial promotions if those promotions are capable of having an effect in the UK. They define crypto assets pretty broadly, and it's probably no coincidence that this is hot on the heels of the developments in Europe through the MiCA regulation. So just very briefly, what FISMA 2023 does. The first thing it does is on regulated activities. So if your crypto type of activity falls within the definition of regulated activity, it means that you can't carry that out unless you are an authorized person or you have an exemption. And on financial promotion, of persons prohibited from communicating an invitation or inducement to engage in investment activity capable of having an effect in the UK, i.e. you don't have to be in the UK, but if you're promoting to people in the UK, this bites, unless you're authorized by the FCA or you've received approval from someone who is authorized by the FCA or you're covered by an exemption. And the intention is essentially to make sure that promotions written to crypto are clear, fair, not misleading. And I should say there is an exemption for certain crypto exchange providers and custodian wallet providers who are not authorized persons, but are registered in the UK for anti-money laundering purposes, as long as they're dealing in qualifying crypto, particular types of crypto. Those are the main two things that the Act does. It does another couple of things that I'll go over very briefly. It introduces what's called the designated activities regime. Now, no activities fall under that regime, but it's expected that what they will do is they'll bring certain activities under the regime in future and regulate them in a particular way. And it'll be things like short selling, for example. So it'll be to make us closer to Europe and the way that Europe regulates things. So although we've Brexited, we haven't fully sailed away from Europe. It also grants the Bank of England and the Treasury with increased powers to regulate digital settlement assets, which will mostly be stable coins. And the final thing it does, which is quite interesting, is it gives the Treasury the power to establish financial market infrastructure sandboxes. So to test and assess new technology. So that's the innovation side of things. And the first one of those is going to be to facilitate the testing of digital securities. So that's really an overview. So what do you need to do? Well, if you are engaged in crypto activities in the UK, you need to check those rules. If you're not already authorized, you need to see whether you can get an exemption. I suppose consumers might want to check whether those they're dealing with are complying with the rules. If they're not, it might hint at other issues with those entities. And the view from clients, well, I'll just finish off with the view from clients is that this is going to be a good thing. So I was speaking to a crypto exchange a couple of weeks ago, and they were saying that their main concern, the main thing that's going to stop their growth really in the UK is market perception, concern about this being an unregulated, sector that's very dangerous. And they think that actually some of the bigger players will come into the market if they can get the UK can get the regulation right, which is going to be good for everyone.
Thank you. I'd like to move now to cryptocurrency-related fraud. Now, the Canadian Anti-Fraud Centre says that Canadians reported just over $300 million in losses due to investment fraud in 2022, compared to $164 million in 2021. Also, many of those reports involved Canadians investing in cryptocurrency. Similarly, the U.S. Department of Justice says that in 2022, investment fraud caused the highest losses of any scam reported by the public to the FBI's Internet Crimes Complaint Center, totaling $3.31 billion. The DOJ went on to say that frauds involving cryptocurrency represented the majority of those scams. Michael, can you discuss the types of cryptocurrency-related fraud that's out there? Oh, you're muted again, Michael.
Thank you. The most prominent type of cryptocurrency fraud that we've seen both recently and over the past probably 5, 6, 7 years would be what are called account takeover cases. And we've seen them, they're really an outbranching of traditional finance account takeover cases. At the end of the day, it's quite difficult to hack into a U.S. cryptocurrency exchange or a U.S. bank or a U.S. stock brokerage and steal customer assets. What hackers have found and fraudsters have found is an easier target, unfortunately, are phishing attacks and account takeover attacks, which are fairly sophisticated schemes, usually phishing schemes, to gain account holders' information and use it to usually convince the account holder to transfer assets from their stock brokerage or bank, or in this case, cryptocurrency exchange account, off to a fraudster. And so a typical kind of phishing attack would be You've got a vulnerable cryptocurrency exchange customer who's somehow contacted by a fraudster. This fraudster somehow convinces this customer that the customer needs to take their cryptocurrency that's stored on an exchange where they hold an account and send it off to some third-party wallet controlled by the fraudster. In this case, and once it's gone and once it's in the account or the address of a fraudster, it's very, very difficult to go find that fraudster, trace that cryptocurrency, go find it, particularly if you're talking about amounts for $50,000, $200,000, even $1 million or more dollars. I mean, it's very difficult to go trace those down. In those cases, there have been a number of attempts by the victims and attorneys representing the victims to pursue the cryptocurrency exchanges because the fraudster would be an obvious target, but you can't find them. So if you look where there are deep pockets and some smacking of responsibility, a lot of those victims have tried to pursue cryptocurrency exchanges saying, you shouldn't have sent my assets to this fraudster, you should have known better. I would say with some exceptions here and there, those cases do not fare well. And the reason is there's a long history of precedent, both in these cases that I and my colleagues have established. We've worked on hundreds of these things, as well as in the traditional banking sector that say, customer, if you're telling your bank or your cryptocurrency exchange or your stock brokerage to send your assets somewhere else, and that's you telling them, it's not the bank's fault, and there's not a whole lot the bank can do if separately you're being defrauded by someone. Those defenses have had a lot of success. So we still see a lot of that fraud. It's sad. It's tragic. I've seen some real heartbreaking losses, but I think we see a lot less of, a lot fewer of those cases. If you're looking at other types of fraud, we'll talk about the FTX case in a bit. I'm sure that's on everybody's mind. It's certainly on everybody's mind here in the US as we follow the trial of Sam Bankman-Fried. And then the other type of, if we're talking about alleged fraud, the other type of allegation that we see a decent amount of are allegations of securities fraud. Purchasers of cryptocurrency who often in a class action will say, we purchased this crypto asset. It was a security. We were defrauded in the purchase of it, and we lost money. The fraud element is a common theme and common type of claim to assert there because it's very difficult to assert a breach of contract claim or some other sort of claim. Usually, the sale went through as planned. The purchaser got what they expected to get, and just like in the traditional stock or securities fraud case, the way to try to recover some money is to allege, well, yes, you gave me what you were supposed to under the sales agreement, but you promised me something about this asset that turned out not to be true, or you concealed something. As a result, I suffered losses. So those, I would say, would be the main types of fraud cases. The account takeovers being kind of the quintessential fraud that I think we're talking about here.
Thanks, Michael. Christine and Dan, anything to add to what Michael has said?
Sure, yeah. I mean, in the UK, there are three types that we've seen go through the courts. The first is essentially fake investment schemes or platforms. So there were cases of fake initial coin offerings where they tricked people into transferring funds, or people transferring crypto to platforms that actually aren't legitimate platforms, and then they've been unable to withdraw their funds, and they've had it traced, and they've found out that their funds are gone. And I think that the new FISMA rules are geared towards stopping that sort of thing. Ransom scams is another interesting one. One of the first crypto cases in 2019, AA versus Persons Unknown, was where a hacker hacked into a system and said, we'll unlock your system if you send us X amount in crypto. The hacker must have thought it's easy to get away with that. And that's what was done. And actually, I'll come on to this a bit later, that case changed the law in this country in terms of recognizing crypto as property. And then also, as Michael said, sort of hacking type cases where you've managed to either get someone to provide their details through phishing, or you've managed to get their private keys. We've seen a case recently where 2 unique digital artwork NFTs were stolen from a wallet. And there's a case you might be aware of going through the courts at the minute called Tulip Trading, which involves Dr. Craig Wright, who's the individual who claims to be Satoshi Nakamoto, who invented Bitcoin. And he says that his company's private key was stolen. And that meant that his company wasn't able to access £3 billion worth of cryptocurrency. And so that's a fraud on the one side, and on the other side of that case, it's now alleged by the defendant companies that actually the entire claim is a fraud because it's been made up by Dr. Wright, and that's making its way through the courts at the minute. So those are the three main types. The other type is celebrity scams, but that's where people are fooled. Celebrity accounts are hacked, and then they're fooled into investing. That's a type of phishing scam that Michael mentioned.
Thanks, Dan. Christine, anything different from a Canadian perspective?
I don't think there's a whole lot different, but what I would just add to this is, these fake investment schemes or platforms basically inducing people to invest in crypto assets, but the entity is not legitimate. This is one of the most common things that we see. And most of the entities we see in the securities space are outside of Canada. They are registered or purport to be registered in places where we don't necessarily have solid global relations. We can't just call them up and ask the jurisdiction to shut the entity down. And there tends to be a real cloak of secrecy around the entities. What I mean by that is often we don't know who the principals are. The principals don't live where the entity is registered. There is no bricks and mortar building to find or to deal with. And I'll give you just a recent example. We dealt with a company called KuCoin operating out of the Seychelles. We obtained a summons. We asked for cooperation from the local police, which we were able to obtain in enforcing the summons. They went to the address that KuCoin purported to operate out of, and there were 2 kids operating photocopiers who knew nothing about the business, and that was it. Nothing else to find. I mean, there are variations on the theme in terms of types of crypto-related fraud. I think it's important to say, like, whatever's most common or not, there are so many variations on the theme. Pig butchering, which refers to a time-tested, heavily scripted and contact-intensive process, basically to fatten up the prey before slaughter, is what that term refers to. These are often romance scams, but they don't need to be. There's phishing, as Michael mentioned. There's fake job listings, business opportunity scams, giveaways, investment scams, pump and dump schemes. I think Dan mentioned, blackmail or extortion, where the fraudster claims to have embarrassing information about you that they threaten to make public. So there is a vast array or variety of variations on the theme, but I would say what we see most right now is this fake platform kind of issue.
Yeah. And just to add to that, Christine, I think maybe we kind of come at it from different places. We see plenty of that in the US, but as outside counsel, there's not a lot for us to do in a lot of those situations. It often becomes a criminal or regulatory issue. With not a lot of success pursuing the perpetrators generally anyway, unless it's very big and the regulators and prosecutors are really going to throw a lot of effort at it. So they tend not to come our way as much, but we certainly see those in the United States as well.
Okay, thanks all three. I'd like to move now to key cryptocurrency cases. Dan, can you briefly take us through some key themes from English court decisions relating to crypto?
Yeah, absolutely. Yeah. I'll take about 5 or 6 minutes and just run through the key things you need to know about the cases in this jurisdiction. The first thing is that crypto is recognized as property in this jurisdiction, so the remedies relating to property will apply. And there was a paper in 2019 written by the UK Jurisdiction Task Force that did some analysis on this issue, and their conclusion was that although it didn't fit within the traditional types of property, tangible property on the one hand and chose as an action on the other, it should be treated as property. And that was confirmed by the court in the case I mentioned earlier, AA versus Persons Unknown. And the cases after that have essentially reconfirmed that principle. So that case was cryptocurrency. And in 2022, there was the NFTs case that I mentioned as well earlier with the artworks and NFTs. There's at least an arguable case, the court said, that they're property as well. And it's worth noting that these are mostly interim decisions where people are trying to get freezing orders to get their crypto back. So there hasn't been a huge fight yet in a full court decision, but this is where we are in terms of the latest law. The other issue they've grappled with is the lex situs of the crypto, so the law of the place where the object is situated. And that's not straightforward for something like crypto. I think Christine mentioned earlier the difference of multi-jurisdictions, and the lex situs is important because it will determine what remedies are available. You know, if the lex situs is England, then English law will apply. And what they've done, they've gone through a few different iterations of this. The first, they were thinking about domicile, but you know, of the rightful owner of the crypto assets. Now, in the Tulip trading case that I've mentioned, it's the residence of the rightful owner of that crypto. So if your crypto is stolen and you're resident in England, then the English courts will apply English law. There's been a slight doubt cast on that recently because the courts have then said, well, what happens if your crypto has been stolen and then it's been sold to a legitimate purchaser for value in a new jurisdiction? Isn't that where the lex situs should be? But the court backed away from that and decided the case on a different issue. So it's up for grabs, but at the minute it's where you're resident. And that's important because that all affects the remedies that are available, which is what I'll talk about for the next minute or so. And the courts have showed a real willingness to assist the victims of crypto fraud, and most of these cases have involved crypto fraud. And there have been a number of cases where freezing injunctions have been granted to stop misappropriated crypto from moving on further, and what's called Norwich Pharmacal and Bankers Trust orders, which are essentially orders to get information about who holds those assets and where they may be, and you can apply for those orders against crypto exchanges. So just taking one case, for example, there was a case called Ion Science, where they'd managed to obtain a proprietary injunction and a worldwide freezing order and disclosure orders and bankers trust orders against the exchanges. And ultimately, the court allowed the claimants to recover via a third-party debt order. So they found the wallet where the crypto had gone to. That wallet, the crypto had gone, but there was value had been transferred by the exchange. And the court said, okay, you can have that value. And so the debt was owed by the exchange, but the debt was then transferred to the defrauded party to let them recover. And just one more case on that. There's a case recently called Joseph Keen Shing Law versus Persons Unknown. And in that case, the court ordered that crypto, which had been transferred out of the jurisdiction to an innocent exchange, should be transferred back into the jurisdiction, even though it had already been frozen, to prevent it from being further dissipated. Although in that case, the exchange was out of the jurisdiction, didn't actually have to do that if it didn't want to, but the exchange played ball. We mentioned earlier about the difficulty in locating these fraudsters. And one thing that you can do in England is you're allowed to serve proceedings by NFT. And that's useful because if all you've got is a wallet address for the fraudster, you can serve an NFT to that wallet with a link to the case papers and the courts, as long as you have to make an application, you have to satisfy the court that that's, that you have good reason to believe that that's the wallet of the fraudsters and that they would receive it if you put it into the wallet. But the court will say that with permission, that is good service if that's all you can do. And recently, they allowed service exclusively by NFT. So that's something you can do to track down the fraudsters. And the last area I'll mention is exchanges. It's something that Michael mentioned earlier. There is, or there has been, and this goes to Michael's deep pocket point, a willingness to hold exchanges as the constructive trustees of crypto assets. So where the fraudsters transferred away crypto into an exchange, and then the exchange has done something and it's gone. If they fail to comply with their duties as trustees of those assets, they might have to account for the profits of those assets. So there's a case called Deloya versus Persons Unknown, where the court held there's at least a good arguable case that in those circumstances, crypto exchanges hold stolen crypto as constructive trustees, and that gives victims remedy for damages against the exchanges, which is important. And as Michael said, they might be the preferred target because you've got them, you know where they're located, and they've got the deeper pockets. Similarly, in a case called Jones versus Persons Unknown, the High Court was satisfied that a test for summary judgment had been met, and that an exchange was a constructive trustee of the Bitcoin because it controlled the wallet and it had no proprietary interest itself in the Bitcoin. But I'll finish by saying that's not always the case, and exchanges are pushing back. So there was a case called LMN versus Bitflyer, which DLA acted in, And in that case, there was an application made for information from an exchange for a defrauded customer whose crypto had been taken and had gone through various exchanges. And we managed to, essentially, the exchanges agreed, yes, we'll provide some information, but we won't provide as much information as they want because it's unduly arduous. And the court is receptive to that. So it's receptive if you're out there, if you're an exchange thinking about, yes, I should really comply with these types of orders, but how can I limit my own exposure? And finally, the case of Perusida versus Persons Unknown is an example of the court saying, you are not a constructive trust exchange. And what happened there, an individual made a claim for a freezing injunction against a fraudster and an exchange and said that the exchange was a constructive trustee. But in that instance, what happened with the exchange is the money was transferred, or the crypto was transferred to the exchange. The exchange then swept the wallet and transferred the value of the crypto to the wallet. And in those circumstances, the trustee, the crypto exchange wasn't a trustee, they were a bona fide purchaser for value of the crypto. So the takeaway is there's lots you can do in this jurisdiction, but if you're an exchange, an innocent exchange caught up in this, think about what's reasonable, what the court might require you to do, but don't be afraid of pushing back if claimants have overstretched.
Thanks, Dan. Christine, can you tell us about the types of cryptocurrency-related cases that the OSC is seeing in enforcement and the cases that the OSC has prosecuted?
Sure. I'll start with what we have done or are doing. There are 5 types of enforcement activities that we have undertaken in this space. The first would be what we would call traditional enforcement. So we conduct a traditional investigation in the usual manner, and then we prosecute it before the tribunal, and we seek sanctions such as fines, restrictions, etc. We have done maybe 11 to 13 of those cases where we are dealing with early platforms with derivative products or crypto products. An example would be the Ava Trade case. These cases are meant to send general deterrence messages, and those messages obviously vary from case to case depending on the specific subject matter of the individual case. The second type is that post April 2021, the period of time after that guidance I mentioned earlier, the March 2021 guidance, we did a series of smaller cases, not as much for general deterrence as it was to bring crypto firms into compliance. So we had issued this guidance basically saying you need to register. And so we conducted a number of cases where our investigation was very light. It was basically done to determine whether a firm was operating in Ontario without registration. So we would open an account on the platform, take screenshots, find out whether there were Ontario investors, and then take action. Poloniex, KuCoin, Bybit, those are all examples of that type of enforcement. The third type of activity was cases against exchanges. So for example, we had a case against CoinSquare, which in addition to being about wash trading was also our first action about reprisal against a whistleblower. So that was a real milestone case for us. The fourth type of activity, I mentioned Quadriga very briefly earlier. In that case, we conducted a full investigation the way we normally would, but we prepared a report rather than seeking sanctions. So we prepared a report. It was made public in June of 2020. And our view was that the best deterrent message and best investor education could be sent by that means in that particular case. This was not a case in which sanctions were sought. And as many know, the principal of that company had passed away well prior to the issuance of that report. So, prosecution wasn't really going to be an effective deterrence message. The man was no longer around. The fifth type of activity is that we also regularly issue investor alerts and news releases about those alerts. So in September, the Globe and Mail reported that between July of 2022 and June of 2023, members of the CSA issued a total of 758 investor alerts, cautions, and warnings. That was a very significant increase, a 221% increase over the prior year. And I can tell you the OSC has been very active in that space. So those are the 5 types of enforcement activities that we have undertaken in the space. As for what we're seeing, as I mentioned earlier, primarily we see complaints about what we would call global websites. So The number of Canadians or Ontarians affected by each website seems to be small, but there are many, many, many of these websites. And the websites are copied and reposted with different names, URLs, different wrappers on a regular basis. Sometimes there are spoofs of what appear to be legitimate sites, but then the addresses don't make sense. Where they're asked to send money doesn't make sense. The outlandish promised returns make no sense. And yet, none of those factors, unfortunately, seem to influence what people are doing or their investment choices. And so sometimes we've issued alerts, but people don't look for them or see them until after they have invested or lost money. And this type of scam affects the population really quite broadly. It can be seniors, it can be young people, everyone in between. The scams are broadly targeted. They affect a lot of people, and they involve surprisingly large amounts of money, often, people's entire retirement savings. We would say FOMO, fear of missing out, is feeding the risk-taking behavior. And it's really surprising that many people continue to take the high risks given some of the large scale failures we've seen, but the failures don't seem to have an impact. People are still getting caught up in the hype, I guess. So those are the types of things we're seeing.
Thanks, Christine. And last but definitely not least, Michael, can you give us a view of the cryptocurrency case law in the US?
Yeah, I'll try to divide it up into some main types of thematic groupings. So first is obviously FTX. I promise we are going to talk about that. The next is there are a set of bankruptcy cases of very large crypto businesses, Genesis, Celsius. My practice involves very little interaction with bankruptcy, so I don't have a ton of insight other than that I know that these are going on. These are huge cases that involve and impact large numbers of consumers who are hoping to be made whole with assets that may have been held on those platforms. So those are ongoing. There are a number of one-off cases. These are probably one of the largest grouping of cases that don't necessarily have any particular theme. They just have sort of crypto blockchain related elements. I recently won a securities fraud and a trade secret claim on behalf of the founder of a very large prominent DeFi protocol. Currently prosecuting a large trademark infringement claim on behalf of an NFT platform against another NFT platform. There have been a number of cases that I've worked on in the trademark space. So there are a lot of these one-off cases. But thematically, the biggest set of cases that we're seeing and the most important set of cases, and I alluded to this earlier, are these securities cases. And the whole reason is if cryptocurrencies are considered to be securities in the United States, the SEC has seemingly and arguably had the power to say, you can't operate these cryptocurrency exchanges, you can't sell these cryptocurrencies in the United States. So this all stems from, I'll just give a very quick background. This all stems from several years ago, the SEC, probably 2016, 2017, I forget the exact year, started talking about the fact that some of these cryptocurrencies might constitute securities. And the SEC brought a few early enforcement cases, but nothing big, and not a lot of guidance was given. Over the years, the SEC then brought a series of enforcement cases against 4 issuers, Kik, Telegram, Library, and Ripple, arguing that those issuers had sold unregistered securities. The court prevailed in the Kik, Telegram, and Library cases. The Ripple case is ongoing. The procedural posture of that case is way too complex to get into in the next few minutes, but there have been some mixed decisions issued in that case. And the industry was left wondering, okay, what is going to happen next? I think probably the whole world has heard a lot about FTX and Sam Bankman-Fried. FTX was one of the world's largest cryptocurrency exchanges. It was actually one of the newer exchanges, certainly in the US and probably around the world. You may have seen it because not only was it a huge cryptocurrency exchange, but it got a lot of endorsements and marketing from celebrities. Tom Brady, Steph Curry, it had its name on stadiums. You were seeing FTX everywhere. And then very quickly, with late last year, a situation emerged where, and we'll get into exactly what happened, but customers were unable to withdraw amounts from their accounts at FTX. There was sort of a run on FTX. FTX went into bankruptcy, and the federal prosecutors in the Southern District of New York, which is the federal prosecutors in Manhattan, New York, filed criminal charges against Sam Bankman-Fried. I keep calling him SBF. He was the founder and large owner of FTX. I'll just call him SBF. I think people know who I'm talking about. And the case is incredibly complex, but I'm just going to try to summarize it at a high level and somewhat oversimplified way. Essentially, a cryptocurrency exchange, kind of like a number of other institutions, when customers go on to a cryptocurrency exchange, they send their money, usually fiat money, from their bank account to a bank account held at or by the cryptocurrency exchange, and then they can use that money to trade cryptocurrency with other customers. And so the cryptocurrency exchange essentially holds this fiat money as well as all the customers' cryptocurrency. There are a lot of very interesting debates given different regulatory regimes about what the cryptocurrency exchange is allowed to do with that cryptocurrency and money that it holds. For instance, if you think about a bank does something sort of similar. It holds customers' deposits, but then it goes and lends out 90% of those deposits. Cryptocurrency exchanges are generally not banks. They're regulated very differently, but the same thematic question about what they can do with the assets emerges. The allegations in the FTX criminal prosecution are that FTX and Sam Bankman-Fried in particular took those assets and used them for other purposes, specifically purposes that benefited Sam Bankman-Fried, maybe other founders. It included paying the debts and funding another organization that he created and ran, a hedge fund called Alameda Research. It included giving lenders to founders and high-level officials at FTX. These are the allegations. Paying for expenses like office renovations and large apartments in the Bahamas. And the allegation, it's a fraud allegation. There are a set of fraud charges brought against Sam Bankman-Fried, are that he told customers that that's not what he was doing, that he was keeping customer assets at FTX when in reality he was doing this other thing and he knew that he was doing it. It's a fascinating case. The federal government has a number of cooperating witnesses that have been testifying over the past week, including his ex-girlfriend, sort of one of the founders of all of this, Caroline Ellison. The prosecution is expected to put on more witnesses than the defense will have an opportunity to put on its case. It remains to be seen whether Sam Bankman-Fried is going to testify, which is a very unusual thing in a criminal case, and the trial is expected to probably last about another month. So there are a lot of interesting questions about whether this is a one-off or whether this has implications for other cryptocurrency exchanges and maybe other businesses in the space, but I'll at least pause there.
Essentially, is this really a crypto case, or is it more a fraud case that involves cryptocurrency? What lessons can be learned from it? And one thing I've noticed is that, we talked earlier about the difficulty of, how rare it is. I think, Michael, you're saying to hack a cryptocurrency exchange, but I think that's an allegation. That's exactly what happened, that $400 million or so were hacked out of this exchange while stuff was going on at the same time. And just what lessons are there from this case right now, realizing it's not over yet?
I can go first, and I'm sure the others have thoughts. So there are a lot of people who say, oh, this is just a one-off. This is a fraud. But, I think this does bring to light, as I mentioned, the question of what does a cryptocurrency exchange do with these billions of dollars of customer assets that it holds? The regulatory requirements are not always so clear. This also, I can tell you, pertains, I think, to stablecoin issuers who take money in and then hold it somewhere, and they probably don't have, depending on the structure, the same relationship with the purchasers of a stable coin that a cryptocurrency exchange has with its customers. But I can tell you what we've seen is a variety of approaches where some cryptocurrency exchanges and some stablecoin issuers have taken the position that we're not going to do a whole lot with money that we receive from customers. Maybe we invest it in some highly liquid things and we keep most of it around. We've seen, on the other hand, some exchanges and some stablecoin issuers take that money and say, hey, look, banks get to lend out money. Why can't we go take and invest this money and make profits on it as long as it's available for customers? Obviously, there's the question about are you communicating clearly to customers what you're doing with it and not misrepresenting anything? But then there's, of course, the separate regulatory question, which can differ by the type of regulated institution, the type of jurisdiction. What are you allowed to do with these customer assets? And in the case of stablecoin issuers, are these really customer assets anyway? I think that's a fascinating question that we're really just glossing over here, but I'll pause there if the others have comments.
Christine, Dan?
Yeah, I'll
Christine,
jump
if
in.
you want to go first.
Sorry, yeah, I'll jump in to say, it's interesting that I think you asked the question, is this really about cryptocurrency or if it's just a fraud case? And it's really interesting that you asked it that way, because we used very similar language in the Quadriga report that I've mentioned a couple of times. We called it an old-fashioned fraud wrapped up in new technology. And I should have said at the outset that the views I'm expressing in this panel discussion are my own and not those of the OSC. But that's particularly relevant here with an active case before the courts. So I just throw that little disclaimer in here. But, FTX appears, and I'm basing this solely on reports in the press to date, not on the evidence, obviously, which I am not privy to. It appears to be nothing more than a classic misappropriation and fraud. As Michael mentioned, it appears that money was taken from Alameda Research to cover outstanding liabilities of FTX. Now, FTX had loans that were based on the valuation of the FTX utility token, the native token of their ecosystem. It's called FTT, and FTT collapsed, and that led to FTX being unable to cover those outstanding liabilities. The custodial issues that Michael mentioned are a really good argument, I think, in favor of regulatory registration and oversight. In Quadriga, again, to bring it up again, it was essentially almost a one-man operation where he decided to fake the ledger. He assigned fake Bitcoin and fake Ether to clients. He was trading with the idea that Bitcoin would go down in value and Ether would go up, but it didn't. And he panicked, and it became a classic Ponzi scheme. And so in that way, it was what I described earlier, an old-fashioned fraud wrapped up in new technology. I should say we published that report on a microsite. It actually won some awards. We participated in the making of a Netflix documentary as well. So for anybody who wants to go and watch something somewhat entertaining on the collapse of Quadriga, there is a documentary on Netflix called Trust No One, The Hunt for the Crypto King. It came out last year. But we hear from people all the time that they look to us to recover their money. But in a scam, it's really important to say, it's long gone, and there's little to nothing a regulator can do to assist with that recovery. And there's also a limit to what a regulator can do given the international nature of these scams. So those are my thoughts on FTX.
Thanks, Christine. Dan?
I agree. I agree with everything Christine just said. I think, on one view, it's just a fraud case and involves crypto. But on the other view, as Michael said, and I agree with this as well, possibly the nature of the business that FTX was doing made it a lot easier to perpetrate such a massive fraud, because it was holding these deposits, it had all this money. And I think possibly also assisted by a lack of understanding of crypto in the market, and the assumption that, SBF knows what he's doing with crypto. He must be very clever, and he must also know what he's doing from a company governance standpoint. I think there's something of that as well. And so that sort of leads to the lesson that I would say is just interrogate what it is you're investing in. Don't trust necessarily companies to do the right thing. Don't trust people based on their reputation. Christine mentioned Ponzi. I mean, classic case, and fraudsters are very often just snake oil salesmen who trick people into believing they're genius. I'd say, long line of people more recently, Madoff and, Elizabeth Holmes of Theranos. SBF's just the latest of those, and the way in which he was able to use deposits, he had access to those deposits, contributed to him being able to perpetrate the fraud. But I think that the mentality of not caring about the rules, as it were, is in the same way as any fraudster, is sort of the underlying cause of it.
One thing I found interesting in reading comments on this case is that the general sense seems to be, at least from my reading, that people involved in the crypto space want SBF to get his just desserts, in a sense. There isn't a sense of, oh, this is going to make us look bad. It's more like, we want justice to be done here, as it were, and that's in everyone's interest. But there's not a lot of support from him in the crypto space right now.
Yeah, I think, look, all of us, my worldview is kind of influenced by the circles in which I run, but I can tell you on the Telegram chats that I'm on and the crypto Twitter, feeds that I follow, there is a lot of that sentiment. I think there's a sense that, hey, he's made the industry look bad. We are not him. This is fraud. You certainly see a lot of that. I agree.
Yeah, I think that's exactly right. He's just staying on the reputation of the industry, essentially, and the industry want him to get his just desserts and move on.
Right. We have only a few minutes left. Christine, can you briefly comment on special investigative challenges that arise when dealing with cryptocurrency investigations? I know there are like at least 6 or 7, so good luck. We've got 3 minutes.
No, I'll try to move quickly through it. So the first one, I think we've talked about multi-jurisdictionality, right? The website might be based in one jurisdiction, operating globally in many jurisdictions with victims around the globe, and there's no template for prosecuting that type of offense. Another one, tracing. Tracing assets is much more challenging than the traditional follow the money. In theory, it's not different from that. But the major difference is the technology used to trace the assets, and finding and analyzing transactions on the blockchain is very specialized. And fraudsters are really creative in the way they can hide their transactions on the blockchain. Not all exchanges obtain KYC information, respond to requests for information on the customer, that sort of thing. That leads to another challenge, the inability to identify individuals involved. I did mention this earlier. It's not possible all the time to obtain information about the identity of the people involved in a transaction on the blockchain. And even if the wallet is traced, the jurisdiction involved may have data privacy rules or be unable to supply information of the final location. And of course, even more difficult on like the straight up fraudulent website scams. Requests for assistance. The OSC is a member of the International Organization of Securities Commissions, IOSCO, as well as the Canadian Securities Administrators. So we send and receive requests for assistance with our national and international partners. We need their assistance in obtaining information. That can be really time consuming, and given any given investigation or given multi-jurisdictionality, we can have a lot of RFAs to multiple partners around the globe. And all of that obviously impacts the time involved, or rather the difficulty in timely prosecution. So we're doing what we can. We work with our RCMP partners. Like them, our hands are somewhat tied. As I said, the scams are operating globally, virtually with impunity. And cases like Quadriga and the challenges associated with investigating crypto-related matters has actually led the OSC and other jurisdictions to think about how we can and must change enforcement to be effective in this space. One area we're working on with international partners is international disruption. So finding ways to disrupt activity before it causes harm. And a really good example of that I think people would be interested in is the FCA in London. About 2.5 years ago, they recognized this problem I've been describing of global websites, and they started a disruption project to target those. Now they collect 100,000 URLs daily, and they use algorithms to sift through and search for fraudulent markers. They narrow that down to about 500 websites every day, and then they contact web hosts like GoDaddy and get them to shut down the fraudulent websites. It's an effort to disrupt the misconduct and prevent harm, but it's also essentially a noble game of whack-a-mole, right? Because if a scam website is shut down one day, the next day there's a new URL with a copy of the website that was shut down, maybe slightly modified. And so we at the OSC are working towards something like that as well.
Thank you. Actually, there's one question that's being posed that I wanted to ask you, Christine, before we close, and I recognize we're already a minute over. Can you address briefly the requirement for exchanges to register as MSBs with FinTrack?
Yeah, not an area of expertise for me. So that's really not something I can speak to. FinTrack being a completely different entity and federal sphere, but good question. And maybe Tudor, that's something that your team can follow up with for the
we can. I'll just say right now that
person.
To the extent that there is a very, very good chance that if you are active in this space, you do need to register as an MSB with FinTrack. So I will leave it at that. We're also 1 minute past the deadline. I want to thank very much to Christine, to Michael, and to Dan for participating today. And thank you all of you who showed up and had any questions. If anyone has any follow-up, please email the organizers. We'd be very, very happy to address any of your questions. Thanks again to everyone. Have a good day.
Thanks very much, Tudor.
Thank you very much.